My lord, may I have your lordship leave to mention on matter, my lord. On 24th January, your lordship is pleased to pass this order, my lord. In this matter, my lord, the attachment order from the bank has been removed. But bank is not accepting this order because the name of the bank and the account number is not there. So your lordship kindly incorporate this bank account number, and this is the order, my lord, last order, this attachment order.
The learned counsel for the to be mentioned. পরশু to be mentioned. Please come on.
I am mentioning upon notice. Oh, আচ্ছা।
Wednesday.
Original set commercial division, item number 1.
Lord, I'm appearing for the decree holder execution
This matter I'm
applicant for the petitioner. My Lord, on 24th of January, Lordship was pleased to take up this matter and direct that liberty was given to me to file an application for, my Lord, praying for liberty to deposit an amount before the court. My Lord, this application has been signed only on last Friday, and I'm yet to file it and obtain the master summons.
On 24th January, you sought for an accommodation or something like that.
Yes, my Lord. My Lord, we had to file an application seeking leave to deposit a particular amount, which is mentioned in the decree, before your Lordship. My Lord,
You
that
are a decree holder.
yes, my Lord, the application is made, but my Lord, it was signed only on Friday. My Lord, the petitioner resides outside Calcutta. I'm praying for an adjournment, my Lord, so that I can file the application and obtain the master summons and serve it upon the respondents. My Lord, 1 week's adjournment is enough, Lordship. I'll get it done within this week.
Okay.
I'm-
I appear for judgment letter number 2.
and
The
I'm
only issue here, my lord, is that it's my shares. So the money will essentially have to be given to judgment letter number 1.
My Lord,
Okay.
Previously, they have given the
Allow her to come with an appropriate application. Okay. The learned counsel for the decree holder has sought for an accommodation for filing the relevant application as indicated in order dated 24th January 2024. Stop. The learned counsel for the counsels for the judgment data number
two and I'm for the 3.
3 are present. List the matter on 12th February.
grateful, Lordship.
Next.
Original side matter to be mentioned, item number 1.
আরে তুমি অ্যাপিয়ার করছো এটা আমি করছি না করিনি আচ্ছা
Well, this is that same matter, my lord, if your lordship recalls. That
So you have completed your argument. I think.
everything completed, notes of argument given, they have argued 3 times.
And
They have
want-
also given a list of dates, said that no notes of argument is required to be given.
But,
Thereafter, your lordship gives them an extension that finally kindly come on Monday with your notes of argument. This is exactly where it stands.
Yes, yes. And you are?
I am appearing on behalf of the judgment debtor, my lord. Now, your lordship is very much acquainted, my lord, with the facts of the case, my lord. I'm not going to trouble your lordship with the facts. My lord, only 2 legal points, my lord, which
I do not want to hear. Your learned counsel has completed the argument.
Twice.
I know that. I know that. I'm quite aware of that. My lord, that is the reason why, my lord, I said, my lord, I'm
come
not
back
going to,
come back with list notes of argument.
my lord, I have prepared, my lord.
Submit.
My lord, kindly considers, my lord, only 2 aspects, my lord. One is, my lord,
So
the
whether
issue-
you are new entrant.
my lord, I've been newly briefed in this matter, my lord.
Oh,
Just
have
to
you- have you-
indicate,
Have you
just to
submitted
indicate, my lord, only 2 legal points.
have you submitted vokalatnama?
My lord, we did not, because of the simple
Why?
reason that, my lord,
What is the law? I want to know because I am a junior most judge of this High Court.
I think Mr. Bose will be in a
I tell
better
you, lordship,
position to.
whether there is a change of advocate or a counsel. Well, if a matter has been concluded, not once, twice.
Yes.
But it cannot be reopened once again Because whether I am new or
That
he
is different thing. I want to,
My lord,
he wants to
same
argue.
sets of advocates are there, my lord. I have been newly briefed in this matter.
he is newly
So,
briefed. Advocate on record is the
Advocate on
same.
record is same.
Okay,
Advocate on record is same, my lord. I have been newly briefed in this matter just to indicate, my lord, two legal points, my lord, which
so
I
it
want
is
to-
not your sweet will of your client.
I know that, my lord. I know that, my lord. We should have indicated.
Ask the bank, you are appearing on behalf of this.
Bank.
Come back with the manager, concerned manager, Wednesday.
Concerned manager
Yes, the appearing on behalf of manager, bank or
on
something.
behalf of the bank, my lord. The
Yes.
advocate on record is here. The same advocate on record, my lord.
No, I want to know how after the matter has been concluded, then again you can come back with your renewed prayer for making some new
My
arguments.
lord, only two additional points, my lord, which we would have, my lord, or
Then-
rather
then-
ought to have, my lord, indicated.
Then again he will argue on that point. It will be never-ending process.
So the propriety does not demand that once a hearing is concluded, then you can reopen. That
No,
that
that's
may not
why-
be the right practice.
That's why I asked.
মানে
3 times your lordship had asked him, and your lordship had given
I
them
have
the
asked-
indulgence
I
to
have-
come back.
I'm
I have asked
aware
that
of.
concerned manager of the bank to come over here who gave you that instruction. Do you
My
follow
lord,
me? I'm giving you this
my
opportunity.
lord, my lord, fully bow down to your lordship's observation that, my lord, of course, my lord, if I make, my lord, any additional points, Mr. Bose will have a right to, my lord, again, my lord, reply to the same. My lord, I fully bow down. But this over here, my lord, this is something of execution. My lord, this has nothing to do with, my lord, a prejudicial right, my lord, which he is claiming before your lordship, my lord. It is, my lord, the mode of execution which my learned friend is seeking, my
For
lord.
4 days
have
we have been arguing
assistance.
this, so nobody has realized this. Suddenly, after everything is concluded, and your lordship gave them indulgence, it was concluded on the last
The
day. Your
fact
lordship was
remains-
reserved it for judgment.
Fact remains
Then my
whether,
learned friends,
my lord, whether
whoever
my
was
lord, the
appearing
decree
for the
has been
bank, she
satisfied
said
or
that
not.
kindly give me one more day to file the notes. Your lordship said very well, come back on Monday with the notes.
My lord,
This
the
is all
fact
that was.
remains, my lord, the fact remains, my lord, whether the actual question is, my lord, whether the decree is satisfied or not. My lord. That is the real question.
Actual question was not being addressed all this while. For 4 days of argument, your lordship, my lord, judicial time has been taken, and now it will be my lord, kindly take my note,
My lord,
and my lord, I leave it
My
to your
lord,
lordship.
I leave it to your lordship, my lord. If your lordship thinks, my lord, that, my lord, these 2 points should be in.
You incorporate the same in your.
Put it in the notes.
I have.
Very
I
good.
have.
Thank you. Grateful, man. May I take
What
your
are those
lordship?
points?
My lord, only 2 things, my lord. Section 190,
Briefly.
very briefly, my lord.
Yes.
195, my lord, constitutes, my lord, a right
195 of what?
of the Kolkata Municipal Corporation Act, my lord, constitutes a right, my lord, given me to, my lord, pay my share of the occupier's share, my lord, of the Kolkata Municipal Corporation rates and taxes, my lord. That's number 1.
That has
If-
been argued, I think.
I don't think, my lord, that this point has been.
Extensively argued.
Yeah,
point আছে।
Extensively argued. I dealt with it. That decree is decree. So occupational share of rates
Number
and
one.
taxes.
Secondly,
What argued from your side that it is a statutory dues, so we have to pay. Bank is the
right,
argument
my
of
lord,
the bank.
probably this provision, my lord, was not indicated to your lordship, my lord. So this is the provision.
Na-
Secondly, my lord, at the end of the day, my lord, it is the terms of settlement which your lordship has to see, my lord, in a sacrosanct manner, because any bifurcation of the terms will actually, my lord, constitute a new contract between the parties, which, in my humble and respectful submission, my lord, cannot be done. The terms of settlement says, my lord, it is my obligation to pay, but it doesn't say it is not a reimbursement, my lord.
The settlement.
The settlement.
The settlement is a new set of contract.
It is a set of contracts which has to be considered in a sacrosanct manner, because any bifurcation of the terms would
Okay.
constitute a new contract.
So this is a new set of contract, a new contract. Okay. And the bank is not
The bank's obligation
directed to pay the same to the
to my learned friend's client.
Bank
It
is
is
not directed
only my obligation to pay.
pay the taxes or surcharges, no?
Yes, municipal rates and taxes.
The appellants.
To the decree holder, my lord.
Decree holder. Sorry. That's all.
And the next point is order 21 rule 1 gives me a right, my lord, to make payment by way of any mode, my lord.
That's all.
Yes, my lord. These 3 points, my lord.
But can I
Anything
take
to
30
say?
seconds, my lord? Firstly, my lord, this is a compromise decree under the terms of settlement. The terms of settlement has become a decree of court affirmed by the appeal court.
Hmm.
I don't know what is he talking about. And the terms and the decree, today it's a money decree. Decree requires him to pay. He has paid half of it, part of it, the remaining is my execution, number
But
one.
he is saying that there is no contract that the amount has to be paid to you.
Yes, that's the terms of settlement. That's the terms of settlement. That's the decree of the court.
He's
That
telling-
is the, yeah, of course,
I
that is
shall
the
go- I shall-
decree
I
of the
shall go
court,
through the-
and there are at least 20 orders
Yes.
in the execution which has unequivocally recorded that I have already paid the tax and I'm asking for reimbursement. None of those orders are under challenge. None of those orders have been challenged. And finally, the appeal court has taken into consideration. So now whether they have paid their dues, their proportionate share of the enhanced view to the corporation is immaterial so far as the execution of the decree is concerned. Under the decree, you are liable to pay, you have to pay. And my lord, last order 21 rule 1, if it is a money decree, you have to pay money. You cannot secure it. There's no question of security or furnishing any other mode to satisfy.
No,
You
mode of
have to
payment.
pay
Mode of
by
payment.
payment.
It's
To me, to the decree holder, not to XYZ, to the decree holder. That's the satisfaction of the decree under order 21. Satisfaction of the
it
decree.
is the
To be
mode of
paid
payment.
to the decree
Order
holder.
21 rule 20.
To
Order
rule 1.
21 rule 1.
Yes.
Satisfaction of the decree to the decree holder, you have to make the payment, not to others.
Rule 1.
Rule 1 sub rule B. By any other mode wherein payment is evidenced by writing. And my lord,
So the money has to come to me in any ways.
and my lord, kindly my lord, will consider, my lord, the terms of settlement. It doesn't say that it has to be paid to the decree holder, my lord.
I have already
yes,
noted
yes,
down.
Yes.
Okay.
And there are no orders, my lord, recording that they have made payment.
Okay.
Well, that Justice Shonji Banerjee's order, your lordship, have repeatedly recorded. It's
So you are ready with your
notes. Sir.
okay. The
Ready.
learned counsel for the judgment debtor has submitted written notes of argument. Stop. Copy served. No.
No. Copy has not been served.
You-
My
you
lord,
have-
neither we have,
also-
my lord,
No,
received.
that's okay. That's okay. None of party. We've not exchanged.
কি হলো ওখানটা?
বলেই দিলে তো।
Stop. The learned counsel for the decree holder is present. Stop. The judgment hearing is concluded for all practical purposes. Stop. Judgment is reserved. CAB.
I'm grateful to your lordship, my lord.
Okay.
Great.
এই এটা চলে গেল দেখো
হ্যাঁ।
এই লিস্টটা চলে গেছে ওদের সঙ্গে দেখো লিস্ট এটা হ্যাঁ ইয়েস on last occasion you are not present.
Yes, my lord, I was stuck in NCLT, that is why.
Your senior has come.
My senior was there.
For orders, item number 2.
May it please, my lord. I appear for the judgment debtor.
GA3 application.
Yes, my lord, GA3,
GA3 was their application.
2023.
And 3 crore. 2 and একসাথে।
23.
GA4, no?
GA4, I'm sorry, my lord. GA4.
GA4 is praying for 47. That's
47, section
Which
47.
we argued threadbare, my lord. I did not
Both of us had argued, my lord.
use an affidavit. I said we
Yes.
don't need an affidavit. The facts are very clear. All the points have been argued right up to the Supreme Court and the division bench of the Delhi High Court. All the matters have been decided. There's nothing new. These are hit by, my lord, principles of res judicata and constructive res judicata. I cited a decision also.
So judgment is completed. Now you are again trying to argue.
No, I just
Lord, we had also cited a judgment on section 47, a very recent one.
judgment
Yes, yes.
is complete, my lordship.
Then but you got the opportunity, Mr. Alim.
Yes, my
Your
lord.
client got the opportunity.
My lord, we were not even aware till the year 2017 when this execution was filed.
No, not
Hence, we
execution.
couldn't.
Not execution. I am saying that
Challenging the decree and everything in
We
Delhi.
have challenged. We had
And-
challenged as well. Only, but because of the department's latches,
accordingly, the GA4 of 2023 stands dismissed with a cost assessed at rupees 10,000 to be paid by the KMC to the decree holder within a fortnight from the date, failing which the decree holder is at liberty to take appropriate steps against KMC. The judgment debtor KMC is directed to pay the due amount under the decree to the decree holder within 15 days. In default, worship steps will follow.
My lord, so
This is the matter on 26 February 2024.
so deeply obliged.
great.
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 Yes. Next. Yes.
Item number 4,
Yes.
pass over.
PO.
Item number 5,
I'm for the decree holder. This is for withdrawal. I'm praying for a short passover. My senior is on his legs.
Who is your senior?
Mr. Orko Provotion.
Okay.
pass over. Item number 6,
Passover.
pass over. Fix করেছো? কোথায়? 6 টা pass over হলো। Item number 7,
7, my lord, I appear for the decree holder. My lord, I was humbly praying if your lordship would kindly grant us leave to come back after a week. The reason being, my lord, we have just been informed that the judgment debtor died on 23rd of January 2024.
Which was the judgment debtor?
I'm appearing for the judgment debtor.
All the judgment debtors are only one judgment
There's
debtor.
only one judgment debtor, my lord.
He died. When?
Last month, 23rd.
এই দেখি এটা দেখি লাস্ট অর্ডারটা দেখি
So last time we had taken time on the ground that, my lord, an appeal is pending and there's no stay in the appeal. There's a stay in the appeal, my lord.
to stay in the appeal.
Yes, my lord. There's an appeal which had been preferred by the judgment debtors. I'm for the decree holder.
Your junior is present.
Yes.
Yes, my lord.
The learned counsel for the decree holder has submitted that the judgment debtor Rajaram Saraf died on 23rd January 2024. Stop. The learned counsel appearing for the judgment debtor has also submitted that the judgment debtor died on the said date. Stop. The decree holder is to take appropriate steps. Stop. List the matter. When?
My lord, 2 weeks hence, my lord, we'll take steps to amend the execution and implead his son.
19th February.
And my lord, in the meantime, my lord, particulars of the heirs of the deceased judgment debtor be provided to us.
19th February. Judgment debtor, the learned counsel for the judgment debtor is to supply the particulars of the legal heirs of the deceased judgment debtor in the meantime. That's all.
That's grateful, my lord.
item number 8, pass over. Item number 9.
My lord, I appear for the decree holder. In the previous order, my lord, you had given us an time to file a tabular statement stating that we had to still get a interest part from that part. I'm praying for a not today, my lord.
Not today.
Not today. Item number 10.
Lordship, I beg to appear under the decree holder. Lordship, on the last occasion, your Lordship was pleased to appoint the receiver to take the Lordship possession of the Lordship, the property disclosed in the Lordship application, Lordship. And the receiver is
Who
here.
is for the judgment debtor?
Lordship, they was not they are not appearing, Lordship, in the matter. So on the consecutive days, Lordship, we have served in compliance with the honorable court's order, Lordship. But
এই সাথে
It has been stated that we will make an inventory of the immovable properties.
Lordship,
How can it be done?
Lordship, that's Lordship. I subsequently found that, Lordship.
Yes.
Lordship, from the order, Lordship, it should the move. If I'm on my humble submission, Lordship, that's a movable property.
এই দেখি একবার tabular statement টা দেখি তো। Is there any application for?
Yes, Lordship. Yes,
What is that application?
Lordship, we prayed for Lordship that to appoint receiver to take the inventory of the Lordship. That is also Lordship in the my
That's why.
care, Lordship.
Ah.
So, but that is impractical, Lordship. I humbly, I really, Lordship.
So you have to pay cost
Lordship, I
for making such an
Lordship, there's a
statement.
typographical Lordship error, Lordship.
But it is your duty to go through the draft
Lordship,
before
I
finalizing.
Lordship, I apologize, Lordship.
Then
I
it is for your
Lordship, I apologize, Lordship. Lordship, that is I also
fault. It has been recorded.
Lordship, I apologize, Lordship. It's a typography.
You are for? Oh, you are the receiver. So have you received any remuneration? What you have done?
As per the direction of your Lordship, I went the place of the judgment letter with previous intimation letter, but then he was not present at that office.
Who?
The judgment letter.
Okay.
Partner of the judgment letter, my lord.
How you have given the notice?
My lord,
how you have served?
My lord, I made a report. Kindly. My lord, kindly come to page number 6.
এই একজন কাউকে পাঠিয়ে দেবে প্রিন্টটা পড়ে গেল পেজ নাম্বার 6 পেজ নাম্বার 6
দুটো কপি আছে আমাকে একটা দিন আছে এক্সট্রা কপি একটা দিন
Mr. Sukanta Ghosh, you have served the
আমাকে করেছেন তো কিন্তু বালাজিকে কিভাবে সার্ভ করেছেন সেটা জানতে চাইছি
Through speed post, my lord.
এটা কোথায় এটা দেখান
In page number 9, my lord.
page number 9 item delivered addressee Balaji. So
One thing I want to submit before your lordship. When I arrived in state address, I found that another firm, namely MS Balaji Sai Impex, was being run in state address instead of Balaji Export, MS Balaji Exports.
Yes.
So two staffs was present at that time. After inquiry, it came to my knowledge that the Mr. Amarjit Roy is a partner of the said firm, and immediately I checked in Google about the firm, namely MS Balaji Exports. I found Amarjit Roy is a partner of the said firm, that is MS Balaji Exports. But two people are the same. But when I arrived, I found the name is different.
Yes.
So without two staffs were present, they could not provide me any information. I communicated through phone, but he said I am in outside, so I could not come for the meeting.
Yes.
So I could not.
The same director, but the company was being run in different
My
name.
name, ma'am.
Yes. Yes.
Lordship, my humble submission, Lordship. This is the Lordship. If your Lordship from the term Balaji, if Lordship can kindly assume, presume that Lordship, that's the same group of companies, Lordship.
Yes.
And most importantly, their Lordship on several occasions, we have served to them, Lordship. And most importantly, the receiver's notice also they have received, and particular date was fixed, but still they was not present just to Lordship vitiate the Lordship proceeding
Yes.
pending before your
So what
Lordship.
is your prayer?
Lordship, may kindly direct to receiver to take the physical position, Lordship.
Have you paid the remuneration?
Yes, Lordship, I have. The remuneration already fixed. That is, I have paid, Lordship.
When?
Lordship, the receiver.
Paid. You have received?
Yes, Lordship.
Okay.
On the very day, Lordship, I have paid.
So, can you satisfy me that there is no appeal pending against the said decree or judge, or no stay order is pending against the state against you or against the said decree in
Lordship,
any higher court?
Lordship, that is, Lordship, on the first day I submitted before your Lordship. So far, we have not received any Lordship notice to that effect. And most importantly, Lordship may kindly appreciate that.
Come back with the said one affidavit to that effect. Come back, I shall pass necessary order that there is no stay order in any higher court or no appeal has been preferred.
Pending, Lordship. Only to that affidavit.
Yes.
Lordship,
To satisfy,
I
satisfy.
shall, Lordship, I shall, Lordship.
Come back on Wednesday. Okay.
Lordship, may kindly give more time, Lordship, because the client stayed at Nagpur, Lordship, so that he need to.
How much?
Lordship, for 2 weeks time, Lordship.
Okay, I can.
Lordship, may I humbly submit?
Yes,
I shall definitely, Lordship.
But this order has to be corrected because immovable properties has been
Lordship,
written
Lordship,
for your application only.
Lordship may kindly give leave to Lordship, rectify the Lordship, if your Lordship may kindly allow leave to Lordship.
Yes, the learned counsel for the
Lordship, before Lordship, may I humbly submit one thing. Lordship may kindly appreciate that, Lordship. We have served them thrice, Lordship. Receiver was there.
I do not know. I am not on that. I am
even if there could have been any Lordship appeal is pending, they could have appeared before your Lordship.
Whatever it may be, this is the direction of the court.
I shall, Lordship.
You can file it on Wednesday.
I shall.
Come back with the affidavit at 2 p.m. I shall pass this order.
Lordship, I shall.
I want to bind you.
Lordship.
Okay.
Lordship.
I want to bind you.
Lordship,
as an advocate of the decree.
I bound to Lordship.
Okay. Yes. The learned counsel for the decree holder has submitted that there is an incorrect application and for which the order dated 21st December 2023 was passed directing the receiver to make an inventory of immovable properties. But it should be movable properties instead. Stop. The Learned Counsel is given liberty to rectify the said mistake. Stop. Para. The learned receiver is also present and she has submitted one report. Let it be kept with the record. Stop. The decree holder is directed to submit an affidavit stating that no appeal is pending against the impugned judgment and decree. Impugned কথাটা relevant judgment and decree, or no stay order has been granted by any higher forum against the said judgment and decree. Stop. List the matter on 19th.
19th, Lordship.
15 days, 19th February.
Lordship.
Stop. In the meantime, you have to rectify everything.
Lordship, I do it right now, Lordship. Right now. It's a small error.
Remuneration has been paid. On 19th, you should come. Okay.
Grateful, Lordship.
Yes.
নাম দিয়েছে বললো বললো তো স্যার আইটেম নাম্বার 11
Lordship, in item number 11, pursuant to your Lordship's direction on 29 January
You are appearing on behalf of whom?
Lordship, I am appearing for the decree holder.
Yes.
Lordship, one notice has been served to the judgment data. Lordship, but what happened, Mr. Saurav Mitra, who is appearing for the judgment data, his chamber has been continuously closed and he is not reachable on his mobile phone. That's why, Your Lordship, a notice has been sent to the judgment debtors in their residential address. But Your Lordship, since they are residing at Delhi, the notice has not been delivered to them. Lordship, I am praying for 4-week time, Your Lordship.
Decree for possession passed by. The learned counsel for the decree holder has submitted that due to closure of the chamber of the learned counsel of the judgment debtor, the notice could not have been served, could not be served upon him. Stop. He seeks for an accommodation for 4 weeks for pausing service of the notice upon the judgment debtor, whose office is at New Delhi or Delhi. Delhi. Stop. List the matter after 4 weeks. 4th March.
Deeply obliged.
Give your attendance. Clearance. ঠিক আছে হয়ে গেল আর কি 500 এখনো আছে
pass over matter item number 4
Well, this is my
এই 4 কোথায়
কোন নেই
দেখি রেকর্ড দেখি None appears on behalf of কেউ নেই তো None appears on behalf of the decree holder. Stop. It appears that on 29th January 2024, none was present from the side of the decree holder, even in the second court. Stop. For ends of justice, the matter was adjourned and the matter was listed today. Stop. Para. Today also, none appears on behalf of the decree holder, even after second call. Stop. It appears that decree holder is not interested to proceed with this execution case. Stop. Para. The instant execution case stands dismissed. Next.
item number 5
my lord, I am for the decree holder, my lord. I have taken out an application, my lord,
since the matter has been settled inter se the parties, my lord, the memorandum of meeting which reflects the settlement between the parties and the debt has been paid off, that is also annexed to my application. Now, my lord, on the last occasion, your lordship was pleased to direct me to inform the learned special officer to make himself available before your lordship.
In terms of my lord's direction of appearing, I was appointed as the special officer, my lord.
Oh,
Since
what is
it
your
has
name?
been, Shatadip Bhattacharya.
Achha, yes.
But since, my lord, it's been settled, my lord, kindly discharges me, my lord.
What is the judgment letter?
My lord, I believe she is not appearing. It's a very sharp practice undertaken by them because your lordship will kindly recollect on the last occasion they had made a prayer for discharge for return of their share certificates which were deposited with the learned registrar original side. My lord, and I also took out a plea before your lordship that since the special officer was no remuneration was fixed and there was extensive meetings held, there were close to 11 and 12, my lord, some remuneration should be fixed, which should be borne by both the parties 50-50. All right, I'm sure.
No, I cannot dispose of the matter unless payment is made. I do not.
There is no remuneration fixed, my lord. Justice Kapoor.
Kindly put me into an embarrassment, my lord. The Justice Kapoor, while appointing me, did not fix any remuneration. My lord, it kindly discharges me, my lord.
No remuneration.
My lord, but it is very embarrassing. My lord. He is a senior member of the bar, my lord. I cannot.
No, I cannot. He is my officer.
My lord, he has extensively done his duties pursuant to the court's order, my lord. It is our duty to pay him a remuneration.
What should have been the exact amount? What should be the exact amount?
My lord,
I am asking you.
I do not know, my lord. My lord, whatever your lordship decides, my lord, it should be borne jointly by the parties herein.
So 200 GMs. Sorry, 2000 GMs. Okay, and you have to pay 1000 GMs.
Yes,
You
my
pay
lord.
1000
My lord will kindly indicate that in the order. And my lord will make it a mandatory order for the judgment debtors to pay as well.
Yes.
This is a very sharp practice, my lord. I'm sorry to say this, make this submission before this honorable court, but this is not done.
The learned counsel for the decree holder is present and submitted that the receiver did not receive any remuneration. Stop. The learned receiver, Mr. Satodip
My lord,
Bhattacharya.
it's a special officer.
Special officer.
Special officer, sorry. Special learned special officer. Stop. The learned special officer, Mr. Satodip Bhattacharya, is present and he wants to be discharged from this case. Stop. He has performed his duty as per as per direction of this court. Stop. However, his remuneration should be 2000 GMs. Both the parties shall pay the 50% of the remuneration as fixed by this court to the learned special officer. Stop. The learned counsel for the decree holder has submitted that his client is ready and willing to pay the same. When?
17 by a week's time? Huh? By a week's time?
By 7 days. Okay. This is the matter on 13th February.
Will it be my lord's pleasure to discharge me, my lord, by this order, my lord?
No, we come back on.
My lord, let there be also a direction upon the categoric direction upon the judgment debtor to also
Judgment
pay it
debtor
by
is
7
also
days.
directed to pay the 50% of the remuneration of the learned special officer as fixed by this court. Okay.
I'm so grateful, my lord.
Please intimate.
Yes, I shall intimate. I'm so grateful.
Sorry to disturb.
No, my lord. I'm endeavoring myself, but it's
okay. Thank you.
Item number 6.
ডিসমিস করে দেবো একদিন করে চান্স দিয়ে সব ডিসমিস কি করার নেই এক্সিকিউশন কেস পেন্ডিং আছে স্পেশাল এভাবে বেঞ্চ করতে হবে এই অর্ডারটাও তাই করে দাও একই করি মানে হ্যাঁ semi order দেয়া আছে 29th January একই rate। সেই জন্য তো রেখেছি যাতে সুবিধা হয় বিস্ফোরণ হয়ে গেল।
Item number 8.
এই 12টার সময় আমার একটা বেঞ্চ আছে
Lordship,
তোমরা তো থাকবে না। হ্যাঁ, তাহলে আমি ঘুরে আসবো এখন। ঠিক আছে।
Lordship, I appear on behalf of the decree holder, Your Lordship, led by Mr. Hon'ble Kaur, my lord. My lord, on the last occasion, that is, Your Lordship may kindly take up the order dated 10th of January, my lord, where
দেখি দেখি
we
10th January আরে কত তারিখ হলো?
My lord, the decree holder has passed away, my lord, and we need some time to take take steps, my lord, to regularize the record, my lord.
We have already given time.
Yes, my lord, but they have not contacted us yet, my lord. We need some time.
The learned counsel for the decree holder has submitted that he needs some more time to regularize the decree, regularize the record, as the decree holder has passed away. Stop. Release the matter when? End of February.
My lord, after 4 weeks, my lord, let it be. Let it
4 weeks
come.
at a time.
My lord, we have not received any instructions. That is the reason why we cannot take
After
steps.
4
my
weeks, we
lord.
shall
I am hopeful, my lord. After 4 weeks, we can get, my lord.
4th March.
Grateful, my lord.
আর কিছু হ্যালো কি সব রেকর্ড কিছুই রেকর্ড আনছে না ভালো তো এতদিন নাকি পেন্ডিং হয়েছিল
Item number 1.
My lord, this is my application. Main challenge in this application is that, my lord, the application, the petitioner, the impugned order is annexed at the end of the application. No, এটা নয়।
জমা করেছিল আগে ছিলাম না
ইমপিউন্ড অর্ডারটা দাওনি তো? I am for the revisionist, my lord. I am appearing on behalf of the Topon Roy, and my lord,
I am for the estate, my lord.
Should I appear for the bank?
my lord, kindly come to the page 60. My lord, before that, yes, page 60. The impugned order starts from page 59. August, the order dated 13th August 2023. Today is fixed for report of the from the concerned Boranagar police. Boranagar complainant takes no steps. A report is received from the concerned Boranagar. Considering the relevant paper submitted by the concerned PS, MP case number such and such is dropped. My lord, that is at annexure P1. Yes, page number, my lord, 17. This is an application under 156 clause 3, my lord, and the contention of the revisionist is this, my lord. There is charges embezzlement of fund, my lord. And there is also a direction passed by the single judge of this court, my lord, under the 226 jurisdiction, my lord. That is at page, my lord, I'm coming. Yes. Yes, my lord, that is, it's starting from page 17 onwards, my lord. The contention starts that accused number 1, 2, 3 are the delinquent bank officer of the HDFC Bank, and the offense under section 420, 406, read with section 34 of the IPC, as contended in the representation dated 18th March as annexed P1 to this application. The instant application is being filed following the order passed on 31st July 2023, passed in WPN, where His Lordship, my Lord Justice J. Shengupta, my Lord, directed the petitioner to approach this application under section 156 clause 3. And my Lord, the contention is that the petitioner on 13th February 2023, the accused person number 1 have already claimed by an intimation dated Yes, 3-1. That is the intimated dated 23rd January 2023 that said respondent number 5 have recalled the entire loan facility with a purported demand of 5,17,000, and the old ornaments which were under the custody of the respondent number 5 kept with as securities for the said amount or to be
So you have taken loan?
Yes, I have.
What is the brief fact?
Brief fact is that, Milord, 4,48,000 some odd amount was obtained loan, Milord, by my wife
Ornament.
by depositing ornaments. And Milord, after 1 year, Milord, it was decided that actually, Milord, the wife was applied for the term loan. And after 1 year, it has been found that the balance, main balance, they have said that your installment is 4,000 and onwards. And it will be appearing from their document even. And Milord, thereafter, the entire loan is standing on the same level, Milord. It is not decreasing, Milord. This is one of the crown, Milord, one of the score of the challenge of the particular assessment. Actually, Milord, every loan is required to be paid by way of monthly installment, Milord, and strict to sensu, Milord, the term of loan is required to be defined. This is number 1 point. Second point is that, Milord, that I am paying interest, that is every month, Milord, often and when. Actually, Milord, the petitioner is also an advocate, Milord. When he is getting some larger amount and depositing that, Milord, it will be appearing that in many occasions
What is the agreement between the bank and the concerned party?
that I have,
How the interest will be paid?
Milord,
Initially, the amount received are usually being satisfied in respect of interest part. The principal portion of the loan remains as it is. The basic principles of banking provisions and so far as loan is concerned.
Milord, this is a gold loan, Milord, and thereafter it was appearing on behalf of my wife, appearing in the name of my wife, and the loan again was transferred in my name, Milord. And during this, yes.
Without your application.
Yes, I have made the application, Milord. What is happened, Milord? That loan was totally paid off, Milord, and that payment was made through a public person, Milord. Means might be a money lender, Milord. That has been arranged by the bank, and bank has assured me that the second time when I will be granted that credit facilities, that is by way of term loan. One 56 class 3 petition, Milord. 3-1. Milord, by later dated certain, that is, I have already read, my lord. I am coming to the 3-2. 2023, the accused person number 1 have already claimed by an intimation dated 23rd January 2023. The said respondent number 5 have recalled the entire loan facility with a purported demand of rupees 5,17,000 and gold ornaments which are under the custody of the respondent number 5.
Who is the respondent number 5?
Respondent number 5 is the principal bank, HDFC, and the
Only three PDS.
Only
Three.
Let's go through the cost item.
Yes, ma'am.
yes, they are the actual.
The respondent number 5. Now, how you have mentioned that without
That is with the principal bank, in the custody of the principal bank, Milord. Next, Milord.
For the entire loan facility, the purported demand of rupees
Yes.
5,17 lakh.
Yes. Then it is required to be mentioned in this context that the accused person number 2 and 3 in collusion with the local antisocial element perpetrated the pre-existing illegal practices beyond the banking norms. And such practice is in contravention of the guidelines of the Reserve Bank of India, schedule bank being HDFC. It is a typographical mistake, Milord. It should be Reserve Bank of India, and HDFC being one of the schedule bank therein. It is further necessary to mention that the wife of the petitioner, namely Basanti Raipal, applied for a term loan of 4,87,000 on 6th April 2021 and offered the gold ornaments as mentioned in the schedule of the said loan document as the securities of the said term loan. But they have converted that term loan into a gold loan. But the accused number 2 and 3 processed the said loan application as overdraft loan of rupees 4,90,000. This is the main contention, including the processes fees and sanction the same on 6th April 2021, being account number such and such, which was continued till 26 June 2022. That is,
You have applied for term loan.
I have applied for the term loan.
Baswanti Rai
Bashwanti Rai is the wife of the petitioner.
applied for
পরে তো ওটাকে
term loan of rupees 4,87,000.
87,000,
4,87,000.
including processing.
Why not 5 lakhs? Why 4,87,000?
No, actually, my lord, Bashwanti Rai was a housewife and he is not entitled to get anything. So his ornaments, her ornaments were being measured by the bank. Might be that is one of the consideration.
Baswanti Rai applied for term loan. Second, sir.
Yes.
When she was granted loan.
It was processed and sanctioned on 6th April as an overdraft loan.
Term loan was paid for.
It is a term loan was paid for, but bank has sanctioned overdraft loan. Overdraft loans means loan against the mortgage.
Granted overdraft loan.
Yes. And the content
5 lakhs 17,000.
17,000 was appearing as an outstanding on the after the 15 months, my lord. Next, my lord, the after the that is on till 26 22 that overdraft loan was carried forward, and the bank has received 92,000 from the wife of the petitioner complaint, which is 19% of the principal amount of rupees 4,80,587.
Civil dispute. Civil dispute, banking rules and regulation norms and everything. So why you have filed this one? Why you have filed the?
No, my lord, my first contention is that this is an embezzlement of fund, my lord.
Embezzlement of fund.
Yes, actually, my lord.
Why this is overdraft loan? Overdraft loan means different thing, I think. You are not clear. You are not clear on this point.
Might be a overdraft loan.
So relation, what is the relation between you, your husband and the bank? What is the relation? Was there any
I'm coming up.
business transaction between?
No. There is no business transactions. With he has no savings account with the HDFC Bank. Thereafter,
Then why the loan account was transferred in the name of the husband of your husband of your petition? Why?
That is after 15 months, my lord.
Why?
That is on the yes. That is on the prayer of my of the petitioner.
Next, come to your point.
And my lord, on that even, my lord, when this loan was transferred, then the entire cash, actually, my lord, it was sought that the entire outstanding balance to be transferred in the name of Tapan Roy Pal, but it has not been made. What they have done, they have involved a particular money lender from the outside of the bank and outsource the entire fund and deposit to the borrower's account and make it zero payment. And thereafter, fresh loan was granted to the petitioner herein.
They are managers or something like that.
They're the relationship managers, my lord. The respondent number.
Have you made any obtain a chief manager of the bank?
My lord, I have made several complaints.
They can approach before the banking ombudsman's matter.
And my lord, then thereafter, my lord, my lord, thereafter, entire thing was again, my lord, same way it was been initiated as an overdraft loan.
There is an embezzlement of fund. By whom?
When this
bank or these three relationship managers?
My lord, these three relationships manager, my lord, who are the party here, my lord. One is customer communication manager. 2 is Ananta, I don't know his surname. And 3 is Payal Banerjee, my lord. So I have instituted an investigation against them, my lord. First of all, my lord, good, bad, indifferent, when the
156.3 was allowed. 156.3 petition was allowed.
No.
By the adjourned
No, it was not allowed, my lord. That is the reason I have appeared before your lordship. If this had been allowed, my lord, then I could not have any grievance, my lord. Magistrate simply
each and every petition filed under section 156(3). That should be the. He can convert it to section 200.
Yes, but here it has not been made, my lord. Here only simply report call for from the police station. That is specifically, my lord, they have also, when I have preferred a writ petition before this honorable court, my lord, and the police has come with that report, my lord, which has been relied on the
report.
My lord, that I am coming. That is at page 32, my lord. This is an application under Article 226 of the Constitution of India, praying for direction upon the respondent authorities to investigate into offence alleged by the present petitioner. Then, my lord, then learned that is affidavit of service filed on behalf of the petitioner is taken on record. Report filed on behalf of the state is also taken on record. The learned counsel appearing on behalf of the petitioner submits as follows. The petitioner taken gold loan from a bank. However, bank authorities thereafter contended that he had applied for a term loan. Higher interest rate was charged. This is one of the contention. In process, my lord, substantial sum was embezzled. Learned counsel for the state relies on a report and submits that after a complaint was made by the petitioner, it was inquired into and found that petitioner was in fault and defaulting loan taken. I have heard the submission of the parties and have perused the writ petition report filed by the state. It is not clear as to why police have chosen to conduct the preliminary inquiry. Because, my lord, there is a direction, my lord, in the Lolita Kumari, my lord, under 154, when the police was received and a complaint under section 154 of the CRPC, my lord, police will not look into the conduct of the complainant, but it will make an inquiry, my lord. Upon registering a diary, my lord, the preliminary inquiry is to be made. My lord, here, even the diary has not been given, my lord. It should be actually have been made clear in the report. However, according to them, offense is made out by the no offense is made out by the bank authorities. The normal recourse available to a petitioner who alleges commission of a non-cognizable offense having a FIR registered is to first approach the local police station, and if it is refused, then superintendent of police, and failing which an application can be filed before the jurisdictional magistrate under section 156 clause 3. So, my lord, thereafter I have given the liberty to take the recourse. So I have taken the liberty, my lord, applied that liberty, my lord. I have approached the jurisdictional magistrate, my lord. Then, my lord, the jurisdictional magistrate also called for the report from the police.
Well, this is the report, my lord, where, my lord, after considering
Police
the
report before your lordship.
of case, my lord, inquiry, my lord, held, my lord, and the report submitted by the investigating officers.
My lord, I am relying upon the 2008 volume 2 SCC page 409, that is Sakri Vasu versus State of Uttar Pradesh.
After filing 156 clause 3 application, my lord, inquiry has been made, my lord.
That is not the provision.
This is the inquiry report, my lord. Yes, my lord. After proper inquiry, my lord, this report has submitted. And yes, my lord. Yes, my lord.
After such and such, the magistrate directed for an inquiry report. If you could challenge this order, no? Order dated 5/8/2023.
Yes.
Challenged 31/8/2000.
31/8/2002.
But you did not challenge 5/8/2000.
5/8/2002 is not made available in the record, my lord. That means in the MP case number such and such, that a particular order was not made available, my lord. Because I have taken all the record, my lord, which was made available in the order in the particular case record. This is the, my lord, in the court of such and such, this is the order, my lord, and there is only one order number 3, but sorry, order dated 31st August 2023. There is no order number, whether this is the first order, second order, or third order. Yes.
What is your prayer?
Prayer is, my lord, the 156 clause 3 is required to be allowed, my lord. The police may be directed to investigate the matter, my lord, so far the embezzlement is concerned.
You have to satisfy that you have come with clean hands. Okay, you have to satisfy. There was a loan account. How you are paying the loan? How you are paying the loan?
I am
each and every month you are paying the loan amount or EMI or what is that? Are you paying the loan amount regularly?
I am coming to the statement, my lord, straightway, my lord. That is at page 57, my lord. My lord, this is the statement, my lord. Am 56 and 57, but I am relying on this, my lord. This is
There is no
57, 57.
thing is 56, 57 and 58.
57 is the loan, is the statement starting from, my lord, 28 June. Your lordship got it?
56 in our 28/6, 2022. Yes. At page 56. Yes, read out. 28/6, 2022.
28/6 2020 amount financed is 5,17,000. Thereafter, my lord, due for stamp duty to bank such and such, such and such, then amount paid 4,92,432. This is the exact amount the bank has paid to credited to my account. Thereafter, due for first installment, then due for second installment, then the entire thing has come 5,20,000. Then, my lord, I have make payment on 28/2/2023, cash of rupees 5,500, thereafter 10,000, and, my lord, on 10th May 2023, I have paid rupees.
What is the agreement that you have to pay the monthly interest?
Agreement, my lord, there is no such actual.
There must be some agreement.
Yes, here is the agreement, my lord.
So, you come back with proper instruction, I think. Now,
My lord, I have given, my lord, the report, my lord, submitted by the investigating officer.
1 minute. You have referred one decision. Please.
This is 2008 volume 2 SCC, page 409. That is in respect of the how the application under 156 clause 3 is required to be dealt with. And another is, my lord, this is Lolita Kumari judgment, my lord, 2014 volume 2 SCC, page 1. Page 1. Lolita Kumari. And this also dealt with section 154, my lord, where the Honorable Apex Court given the guidelines, my lord, how the 154 application, that is how the complaint is required to be dealt with. That every complaint is required to be in view of the aforesaid discussion after.
How the complaint under section 154 CRPC is to be dealt with.
Registration of FIR is mandatory under section, that is the, my lord, after.
Copies of all this. Please.
Lord, I have given the report submitted by the investigating officer. On the basis of that report, my lord, the learned magistrate was pleased to turn down the prayer of the petitioners, my lord. My lord, kindly go through the entire reports, my lord. Your lordship will.
In fact, whether magistrate can without registering or anything like
My
that.
lord, as per as per Priyanka,
Is there any Xerox copy of that
my
receipt?
lord, at that moment, my lord, I have no not my lord,
You have to produce all this AIR 2015.
yes, ma'am.
2015 AIR.
It is my lord voluminous, my lord, judgment, my lord. I think, my lord, minimum page 80, my lord.
এটা AIR
What is the page number?
AIR 2015 milord
AIR SWC.
SWC Supreme Court Weekly SWC
Hey, 2015 or something like that. It has been referred in the order of the learned additional chief judicial magistrate. No, yes, yes.
Lord, from the report, my lord, your lordship will find, my lord, that the matter is entirely civil in nature, my lord, and the appropriate form is there, my lord. They make banking ombudsman is there, my lord, to solve his problem, my lord. So, my lord, rightly the rightly
milord
the
I
London
defer to
magistrate-
this yes
rightly the magistrate, my lord, pass this order, my lord.
Who is you are from the bank? Yes.
Lord, same submission, my lord, the matter is purely civil in nature. Appropriate forum is there. And also, madam, my lord, kindly see page 54. There is a mail from Bank Authority, Mr. Roy.
এই কপিটা পাসনি তুই যখন ইয়ে করেছিস হ্যাঁ
Here,
এটা তো বলেছিলাম তো পুরো দুটো অর্ডার আছে
noted that your client has availed gold loan from HDFC Bank on 20, and at the time of availing such loan, your client has executed an agreement. Avail the said loan, your client has pledged the loan of 199.200 grams. Timely repayment was an important essence of the said loan agreement. However, your client failed and neglected to make payments. As per the agreement, same loan got matured on 28 December, but he has not renewed the gold loan till date. Communication dated 11 January, 23rd January, to 13 February were also served to your client stating all the facts. Moreover, on 13 March, reply of your client's complaint was also served through post informing about the change in policy of upfront interest mode that your clients will be able to renew his loan through monthly interest mode through bank account. Please note that our bank always provides services for the benefit of its customers and as per the applicable guidelines, regulations stipulated by the RBI and or appropriate authority. Hence, all the allegations as you made in your communication are hereby denied, disputed, and the same allegations are not at all maintainable in the eye of law. Please be informed that the above mentioned loan account is already matured on 28 December 2022 and your client's payment of 5500 and 10,000 dated 28 February and 23rd March respectively is adjusted against the principal amount under the above mentioned loan account. It is specifically to be noted that bank has sent several reminder letters on your client's registered mailing address requesting your client to renew or repay the loan outstanding at the earliest. Please note the following letters were sent: letter 1 letter and pre-sale letter dated 11 January, 23rd January, 13 February respectively. Our bank also conducted paper publication in the paper, namely Anandabazar Patrika, dated 11 March 2023. However, even after the same, your client neglected to make payment. Please note, initially, your client has approached for a term loan in the name of his wife, who doesn't have any bank account, and your client was not ready to open a SB account with HDFC. As per our internal norms, term loan can be disbursed with 6 months upfront interest to the external customers exclusively. However, your client was not willing to avail the upfront interest option. Hence, he opted for zero balance OD account instead of 10K regular SB account and availed the OD facility at the rate 10% ROI rate of interest, which
this is the contention of the dispute my lord
consent and OD agreement and was duly signed by his wife in the presence of customer at our gold loan desk with CCTV surveillance. Your client was cleared interest on overdraft account number as per norms and payment pattern. Same has been admitted by your client as he has signed the requisite documents at the time of closure. The above interest does not pertain to your client's above mentioned gold loan as the same has been taken under upfront mode of rupees 24558 has been deducted as upfront interest. No more interest has been paid by your client. Your client was made a payment of 5500 on 28 February, 10,000 23rd March, which has got adjusted against his principal. In these circumstances, we request you to take note as on 3rd April 2023, there is an overdue of rupees 5,17,039 unless your client may pay the said amount on or before 3rd April, the bank would proceed further as per bank's prescribed process to recover its dues as per the clause laid down in the agreement.
There is an agreement between you,
My lord,
client and bank.
yes, there is a agreement between the customer and the bank, but
The report, my lord.
This is a violation of
Purely civil in
features of,
nature.
my lord, first of all, they have to show that in their agreement they have said specifically
this would be a criminal matter. I want to know.
criminal matter, that is, Milord, on initially, from their reply, on initially your client has approached for a term loan in the name of his wife. So, Milord, this has been now, it has been expired that it was first of all, it was applied for a term loan.
Now, what is, just a minute, counsel for the bank. What is the provision for banking ombudsman and everything? Can you highlight anything right now?
Banking
There is an appropriate forum to file.
Banking
Yes. If any, my lord, fraud, any embezzlement.
No, my lord.
Yes, my lord.
And if the matter is purely civil in nature.
Whatever it may be, what is the relevant rules? Can you show me?
That I has to.
My lord, let this matter be kept, my lord. I shall assist your lordship.
And further instruction as also.
I know everybody will assist me. Bring all this at least book.
Ombudsman.
Ombudsman and this ruling you have cited.
Yes.
Okay. When I shall leave the matter?
My lord, today is 5.
Why?
Well, he has to take an instruction from the bank.
No, first of all, my lord, my first contention is that in the law.
Satisfied with your client's contention.
That I have understood.
I want to understand.
My lord, first of all, the bank.
The criminal.
My lord, first of all, the bank has to tell me what is the installment through their agreement.
Show me the agreement first.
Yes.
You have copy also.
I have the copy of the agreement, my lord.
You have submitted with your
Revisional application. It is annexed to the revisional application.
Okay, come back on 19th February. Hey, including learned counsel for the party, including learned counsel.
19th.
Submitted their respective arguments in connection with the relevant matter. However, the learned counsel for the bank has sought for an accommodation for apprising this court.
এখন হবে না পরে যখন 156 তে অ্যালাউ হলো
Ombudsman and other banking regulations regarding recovery of dues from the concerned customer.
Yes, I shall, my lord.
This matter on 19th February. Okay.
And my lord, may I tender this to judgment, my lord?
Yes, why not?
Yes.
On 19th February, please.
Yes.
19th February.
Grateful, my lord. Yes. No, 19th February. এই দাঁড়াও তোমার জাজমেন্ট আমি লিখে নিই
আরে শ্রীবাস্তব প্রিয়াঙ্কা শ্রীবাস্তব
আমি অত পণ্ডিত নই বুঝেছো ঠিক আছে
What is the page number of that? 2050 AIR SWC.
Page number, my lord.
2015.
No. This is not page number. Wait, year, my lord. I shall bring the next date, my lord. I shall bring the Xerox copies of this.
Matter is gold loan. Gold loan is purely civil matter.
Being the
And the additional chief judicial magistrate on the basis of certain judicial reason has asked the police to submit a preliminary.
Police has also submitted that there is no offense on the part of the bank authority.
No, police,
I have to hear him at least his heart's content.
it is already admitted fact, my lord. The application was made. Yes.
Proper preparation.
Yes.
Okay.
Huh?